Hi, I'm Ben Holden, Director of the Reynolds Center for Courts and Media. Now that just about everyone old enough to click a mouse can self-publish their ideas online, it may be tempting for us to think about government censorship as some sort of a media relic, about as relevant to your life as a manual typewriter. But censorship remains a reality in many of our schools and colleges, where the concerns about public relations for the institution can sometimes override honest journalistic principles. Now, when that happens, the public is the loser. And that's especially true now that fewer and fewer professional news organizations have full-time beat reporters covering the campus every day. The First Amendment is an enormously powerful shield that protects us against government interference in what citizens say are right. The Supreme Court recently re-emphasized just this point and told us how powerful it is in the case of Snyder versus Phelps. You may know it as the Westboro Baptist Church case. There, the Supreme Court refused to allow a liability suit against even the most extreme, hurtful, and offensive and inflammatory speech because that speech touched on matters of public concern. As Chief Justice John Roberts wrote, the First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. That's because speech concerning public affairs is more than just self-expression. It's the essence of self-government. Now, if you're involved in any type of publishing or broadcasting, you need to be well informed and you need to know what is and is not protected under the Constitution and the First Amendment of your own state. You can't assume that your school always understands and appreciates the limits of its own authority. You are your own best advocate, and your knowledge of your rights makes you more powerful. Now, here to tell us more about the First Amendment and about censorship is Frank LoMonte, Executive Director of the Student Press Law Center.
The First Amendment is one of those things that people have a tendency to throw around kind of loosely when they get into trouble. You can't do that to me. I know my First Amendment rights. And that frequently precedes being thrown out of a bar, for instance. But what does the First Amendment really cover? What does it really protect you against? Well, the answer is probably more and less than most people think. That's what we're going to spend the next little while talking about, both the legal and the practical side of the First Amendment rights of student journalists when they're on a college campus. And we want to focus not just on your legal rights, but also on the practical and the tactical side of intelligently protecting and asserting your First Amendment rights. Because it's our experience at the Student Press Law Center that taking your school to court is almost never a satisfactory way to get a solution. It's costly, it's time-consuming, and it rarely gets you the result you want, which is to be able to publish what you want to publish when you want to publish it right away. So we're going to talk both about knowing your legal rights and also about how to protect them short of taking your school to court. The first thing to know about the First Amendment is that it is only good against a government agency, a state actor, right? Not against a private employer like the pizza place that you work at. So if you show up at the pizza place wearing your campaign t-shirt and your employer tells you, take that off, you have to put our uniform on while you're on our premises, well, that's sad for you, but it's not a First Amendment violation. A pizza place is a private actor. They can't violate your First Amendment rights, no matter how hard they try. Neither can a private college or a university. So if you're a student at a private institution, you may have other remedies. You may have rules, policies, state-level remedies, but what you don't have as a student journalist at a private institution is a right to take your school to court under the First Amendment to the U.S. Constitution. Okay? So if you are at a public college or university, what level of First Amendment protection do you have? And the answer is, this is why people hate lawyers, it depends. It depends on how your medium is set up and structured and funded to some extent. If you're lucky enough to be at one of those student media outlets that is 100% independent of the school, makes its own money, has its own building, hires and fires all of its own staff, makes all of its own decisions, that newspaper probably ought to be treated no different than a real-world professional newspaper, right? Which is to say, the school can regulate only the time and the place and the manner of the distribution, and those regulations have to give you reasonable access to the campus. They can always tell you, don't put the distribution box in front of the emergency exit, right? Don't block the sidewalk. But what they cannot do is discriminate based on the content of the publication. They cannot say only pro-administration newspapers and not anti-administration newspapers get distributed on our campus. That would be a First Amendment violation. But we all know the more common situation is there's some level of entanglement with the school. You're funded by the school, you're using school premises, maybe you're advised by a faculty advisor, working for credit as part of a class. Once you have that level of entanglement, it's likely that your First Amendment rights are somewhat reduced on campus. Let's start from the beginning. Let's go back to the year 1969 when dinosaurs roamed the earth and your parents or grandparents bought their first pair of bell-bottoms, okay? The Supreme Court decided a case called the Tinker versus Des Moines Independent School District case. We'll call that the Tinker case. And the Tinker case is the case that everybody knows, even if they don't know it, because it's such an important historical case. It's the case where 3 public school students in Iowa showed up at school wearing their anti-war armbands to protest the U.S. involvement in Vietnam. The school tried to punish them for refusing to take off the armbands, and the students took their case under the First Amendment to the federal courts. Case gets all the way to the U.S. Supreme Court, which says, school, you're wrong, students, you're right. That expression was protected by the First Amendment because it was not disruptive of school activities. And that was the standard, quote unquote, material and substantial interference with schoolwork and discipline. That was the threshold for the state to be able to censor the speech, okay? And notice that it says material and substantial disruption. So a little disruption is going to be okay. A little disruption is allowed. And there was disruption in the Tinker case. People would point, people would stare, people would ask questions, people would even get a little angry and maybe get in some back and forth discussions. All of that is okay. All of that's understood. All of that is why we have a First Amendment, right? So if your student media has the protection of the Tinker level of First Amendment rights, that's still not as good as the New York Times or the Wall Street Journal. In the professional context, what the Supreme Court has said is that the government can step in only in the very, very most extreme instance where publishing material is going to literally endanger the national security of the country, like battle plans, right? So it's not as good. It's still the training wheels version of the First Amendment, but it's quite a lot of protection to be protected by the material and substantial disruption standard. It's certainly going to protect the routine news story that you probably are interested in publishing anyway. Are there any questions about that? Yes, go ahead.
So, substantial disruption, what exactly does that mean? I mean, what is substantial disruption?
Well, here's what the courts have said. The courts have said that just publishing material that is controversial, that is critical, that offends some people's sensibilities, that's a little bit risque, all of that is short of substantial disruption. Substantial disruption has got to literally rise to the level that people are getting into fights, they're walking out of class, they're otherwise interfering with the orderly operation of the school. For example, there was a case a few years ago where students wanted to publish material that would, kind of a how-to instruction manual about how to play pranks, how to set off fire alarms, how to set off stink bombs, and how to make the toilets explode on campus. I think we'd all agree that exploding toilets would constitute a substantial disruption of our lives. And so that was not protected under the First Amendment Tinker standard, okay? But it's got to be something like that that actually interferes with the operation of school. So if you want to bring a leaflet to campus and hand it out for Confederate Memorial Day with a Confederate flag on it, the school is not going to be able to stop that unless they can point to factual evidence, not speculation, factual evidence that that symbol has, somewhere in the recent past, actually caused people to act out violently or disruptively. Otherwise, that's protected First Amendment speech. But there's a but attached to Tinker. We have to fast forward to 1988 when the Supreme Court decided a case called the Hazelwood School District versus Kohlmeyer case, and we'll just call that Hazelwood. In the Hazelwood case, the one and only high school newspaper case ever to get to the Supreme Court, here's what happened. Students in a suburb of St. Louis wanted to publish a 2-page spread in their high school newspaper about social issues that were on their minds. Things like divorce, things like teen pregnancy. The principal objected to the content. He had two specific problems. He didn't like the fact that the identity of the pregnant girls was not well disguised, and he didn't like the fact that there was an accusation that a particular kid's father may have been a deadbeat dad, and he didn't get a chance to respond. So the principal used his authority to pull that content and not allow it to go to the printer. The students, knowing the Tinker standard, filed suit, took their First Amendment case to the Supreme Court, which came back in 1988 and said, Tinker is still the rule for personal and individual expression. But when you are speaking in a curricular setting, you're going to have a reduced level of protection. And the kinds of indicia, the kinds of factors that make speech curricular are, you're getting credit, you're working during class time, your assignments are coming from a teacher, all those kinds of things that make something look like a part of your schoolwork instead of a part of an independent, freestanding publication. In that setting, the school need not show a substantial disruption in order to censor. The school can censor based on a lower standard of a legitimate pedagogical justification. Obviously, that is a much lower burden for the school to meet than the substantial disruption standard. Does anyone have any questions about that? Yes, go ahead.
So does any newspaper paid for by the school fall under the Hazelwood rule?
Not necessarily. There was a safety net that the Supreme Court left in the Hazelwood case, and here's what they said. If the publication operates as a public forum for student expression, then the publication can still be entitled to the heightened Tinker level of First Amendment protection. And that phrase, public forum, is how the courts are going to analyze any time a person wants to use government property for individual personal expression. If you want to have a demonstration on the sidewalk or on the steps of the courthouse, the government is going to look at, is that a public forum and is your speaking activity consistent with the purpose and use of that forum, okay? And so if your publication operates as a public forum for student expression, then it is out from under the Hazelwood standard. And this can be as simple as just getting a school district policy declaration that says, our publications are public forums for student expression. The most important factor in deciding whether you are or are not a public forum is this. What is the actual practice on the ground? Have school administrators exercise regularly the right to go in and edit and change the publication? And if that's the case, then it doesn't matter what's on paper. What matters is the practice on the ground. And if that is the case, then you're probably not a public forum. Any questions? Yes, go ahead.
Hazelwood was at a high school, but here we are in a college. Would the same standards apply here as they did in a high school case?
Probably not. There is one court case called the Hosty versus Carter case. It was decided by the Seventh Circuit Court of Appeals in Illinois. And this case said that the starting point for analyzing the First Amendment rights of college journalists is the Hazelwood case. But that case has not been followed by the other federal courts of appeal, and a couple of them have actually rejected it and refused to follow it. And we'll talk a little bit more about this in a minute, even the state where Hosty occurred, Illinois, has rolled back that rule by state legislation, so that under state law today, college journalists are entitled to the Tinker level of protection by virtue of a state statute that operates in effect as an override to the effect of the Hosty decision. So the Hosty rule is the rule only today in the two other states in that circuit, Indiana and Wisconsin, and it is not binding anywhere else. It's kind of hard really to imagine that Hazelwood would be the right standard on a college campus, because if you read the Hazelwood decision, it's largely about protecting the delicate and sensitive ears of these impressionable minors, right? And by the time people get to college, they're almost all 18. They're people who have heard everything and probably seen and done most of it. So it's pretty hard to justify applying the Hazelwood standard on the college campus to people who are legally adults. Does anybody have any questions about anything we've talked about? Go ahead.
What about broadcasting and websites and other types of media? Do the same rules apply?
Well, of course, there's not a ton of history yet out there of internet law, right? And so we have to glean what we can from the cases that have been decided. So far, what the courts have said, including the Supreme Court, is that publishing is publishing is publishing is publishing, and publishing on the internet enjoys the same level of First Amendment protection, no more, no less, than that in print. And so something that is legal to say in print is equally legal to say on your website. Now, broadcasting can be a little different depending on how the broadcast operation is set up. There are differing standards depending on whether you're operating at an FCC licensed over-the-air broadcasting facility or not. If your broadcast operation is an over-the-air FCC licensed facility and it's not an internet-only or a premium cable-only broadcast, then it's going to be subject to a reduced level of First Amendment protection that applies to broadcast stations. The case to know there is the 1978 case from the U.S. Supreme Court called FCC versus Pacifica. And nobody knows it as that, everybody knows it as the 7 Dirty Words case, because this is the case that involves the George Carlin comic monologue, where he talks about the words you can't say on the radio, and of course they played it on the radio. They played it at 2 o'clock in the afternoon when kids were listening, and a parent complained to the FCC. That's how the case got to court. The radio station defended itself and said, look, these words are not obscene. They're within the protection of the First Amendment as we understand it for print and for all other media. But the court came back and said, the FCC has broader regulatory authority over content than would be the case in other media because of the unique impact of over-the-air broadcasting on young people. It comes out of the radio without their being able to screen it, right? And so in that unique setting, the standard is no longer the obscenity standard that applies in all other media. It is the indecency standard. And so speech can be regulated and prohibited and even fined if it falls short of the indecency standard, which the FCC has defined as patently offensive sexual or excretory material. So if you want to have a program of doo-doo jokes, go right ahead, but you got to do it before 6 a.m. or after 10 p.m. when the FCC says it's less likely that children are going to be listening. Any questions? Go ahead.
Now, I understand that these rules apply to news articles and photos and even editorials, but what about advertising? How do these rules apply to ads?
First thing to remember is that advertising is protected First Amendment speech. Don't let anybody tell you otherwise. But the courts have recognized that there is some greater governmental interest in regulating the content of advertising that can justify government intervention that would never be allowed on the editorial page, right? The Federal Trade Commission can penalize you for running a deceptive advertisement where you lie about your product. Thankfully, the government can never penalize you for running a deceptive editorial or a deceptive column. Right? So there are different levels of First Amendment protection. The thing to remember when it comes to the First Amendment rights of student journalists and advertising is the students should make the final judgment calls. If you have a policy set by the school administration at a public institution that screens ads based on content, then it's possible you're not only violating the editor's First Amendment rights, but also those advertisers. The right of the advertiser to speak to that audience can be violated and can give rise to liability for the college if the college gets in the business of screening those ads. What do I mean by that? If the dean of the journalism school decides, under my policy, we won't take ads for abortion clinics, or we won't take ads for gun shops, or whatever, then it's possible that that clinic or that gun shop has a First Amendment claim against the school because it is state action that is stopping them from advertising a product lawful for the audience in that state-funded student media outlet. So what is the lesson? Students should set the standards. Students should make the judgment call. In that case, there's no state action and there's no First Amendment liability. We should, at this point, stop and say a word about the First Amendment rights of faculty, of teachers, and of professors. And a word is about all it's going to take, because the word is no. The word is no. There's almost no First Amendment protection left for speech by public employees in the course of their duties. The Supreme Court decided a case back in 2006 called the Garcetti case, and they drew a dividing line there and said, if you're a government employee and you're speaking in the course of your official duties about matters that you encounter in your performance of your job, you're not speaking as a citizen anymore. You're speaking as an outlet of the government, as a mouthpiece for the government. And that speech can be punished or regulated by your government employer. If you go before the Board of Regents, let's say, as a parent, and you say, as a parent, I'm here to complain that my kid's tuition is too high, that's fine. Now you're speaking as a citizen. Now that's protected by the First Amendment. But if you go as a professor and say, I want to complain about my dean, I want to complain about the vice president, I want to complain about the president, that's not First Amendment protected speech. Now, you might have other remedies. You might have a real good contract, you might have tenure, but you probably don't have a First Amendment constitutional claim if you get called into the president's office and fired. That's important for student journalists to remember, because if you encounter a censorship controversy, it is vital that the students and not the faculty advisor take the lead and be the public voice of that controversy, because the students actually have First Amendment protections superior to their own instructors. That's a good transition into what I really want to focus on, and that is the practical stuff. Okay, I know the law. I'm real smart now. Where does that get me? How can I get myself out of a censorship controversy, or maybe stop one from happening in the first place? Does anybody have any questions about that? Yes, please.
What if the censorship isn't the college actually confiscating the paper or stopping you from publishing? Suppose it's just pressure on you or threatening to cut off your funding, or maybe pulling the college's ads from your paper.
Actually, that is the exact type of censorship that we at the Student Press Law Center encounter much more commonly at the college level. Colleges are pretty savvy. They have figured out that they cannot directly censor the media by leaning over the editor's shoulder and pushing the delete key, right? Can't do that, but what they try to do instead is censor indirectly by bringing pressure to bear by firing the faculty advisor, cutting the budget, taking your office away and moving you out to the barn next to the ag school, right? All those things can be violations of the First Amendment, and here is the standard. If the conduct of the government agency is intended to pressure you into refraining from speech you have a right to say, and if a reasonable person in your position would be threatened or intimidated against speaking, that can still be a First Amendment violation, even if the censorship is indirect. In fact, there was a state court case in California a couple years ago where it was held to be a First Amendment violation when the school did nothing more than just denounce a student's speech after the fact, issuing statements and issuing press releases saying that speech should never have been heard and should never have been published. That was good enough because it sent a message to future students not to write columns like that in the future.
When Angela Mensing took over as editor of her college newspaper at Armstrong Atlantic State University, she was determined to shake things up. Her newspaper, The Inkwell, started asking tough questions and publishing stories that the Savannah College would have preferred to keep quiet. Stories like the college's failure to make complete crime logs available for public inspection at the police station, as federal law requires. Angela was prepared for the irate phone calls and emails and conversations. What she wasn't prepared for was what came next, a $14,000 cut in the newspaper's budget. That news came at a meeting of the Student Senate Budget Committee, where senators flipped through back issues of the Inkwell, pointing out articles they disliked. Then they voted to slash the newspaper's funding by 26%, and the Armstrong administration agreed. Angela went into investigative reporting mode. She compared the Inkwell's funding against all comparable student organizations and showed that only the newspaper was singled out for a budget cut. This looked wrong, but was it illegal? At least 2 federal circuit courts have said that the First Amendment prohibits withdrawing funding from a college publication because of its editorial content. If there is any measurable loss that is substantially motivated by the editor's decisions about what to publish, then the editor's rights have been violated. The Inkwell got legal representation and sued. The case settled almost immediately, with the university fully restoring the entire $14,000 cut and paying the students' attorney fees. The outcome demonstrated that a public college or university can never use its funding authority to retaliate indirectly against speech that it can't censor directly.
So as we saw from looking at the case at Armstrong Atlantic, it can still potentially be a First Amendment violation if you do no more than cut the publication's budget if the budget cuts are motivated by an intent to punish the editor's lawful speech and are not part of a routine across-the-board cut that all institutions on campus are getting. Anybody have any questions? Yes, go ahead.
Well, that sounds great if you're at a public college, but what if you're at a private college? Can they do anything then?
First thing to do if you're at a private college is take a look at the school's own rules and policies and regulations. It's very possible that the school has itself given you some First Amendment-like free speech guarantees. A lot of very good colleges do. Princeton, Notre Dame, Tulane have rules in their own student handbooks that in one way or another simulate the types of protection that a student would enjoy at a public college under the First Amendment. And of course, we all know, all you college students, when you got that student handbook on the first day of school, took it home and read it cover to cover and memorized it, right? We all know that. Take a look at it. See if there are free speech guarantees in there because they may be enforceable as a contract with the school, right? It's almost like you made a bargain. Your mom wrote a $50,000 check to the college and in return you got this spiffy handbook back. That can be a contract. And so the school may have bound itself to give you freedom of speech. Second thing, if you don't find a rule or a contractual remedy, open the window and look outside and see if you're in California. Because if you're in California, you have the benefit of some uniquely good state laws that extend the protection of the First Amendment to the Constitution to students even at private institutions. So that's a point that everyone should keep in mind, that legislatures can always give more civil rights to people than the Constitution guarantees. They just can't give less. California has elected to extend the benefit of First Amendment protection to students at private institutions. And it is possible, it has happened, that students can initiate legislative reforms in their own states. You may also have a remedy under your state constitution. Take a look at the free speech guarantee in your state's constitution. There are at least a few states, New Jersey is one, Washington State is one, where their state equivalent to the First Amendment has been interpreted as being broader than the federal First Amendment. And so it might apply to the conduct of private actors in a way that the federal First Amendment does not. Anyone have any questions? Please, go ahead.
So let's say my rights were violated, I felt my rights were violated, and I didn't want to sue the school or even threaten to sue the school. Are there any remedies I can have short of going to court?
Definitely. Let's talk about the strategy stuff now. Even though the Student Press Law Center is run by lawyers, we never recommend that people run to the courthouse, run to get a lawyer, wave the First Amendment around as a first resort, because it's unlikely to get you the best result. What you want is immediate results, not a declaration from an appeals court 4 years from now that says, hey, remember that editorial you wanted to run 4 years ago? You were right all along. Congratulations, right? That's not an effective remedy. You want to try to negotiate your way out of the censorship, but you want to negotiate from a position of strength. First thing is work your way up the chain of command, okay? Think about who in the chain of command, and this may be all the way up to the Board of Trustees, all the way up to the Board of Regents of your system. Who is reachable? Who is somebody maybe who has some ink running in their veins, right? Somebody with some journalism background, somebody with some legal or civil rights knowledge. That person may be an ally that you can reason with and appeal to. And frankly, if you do go to court, a judge is going to want to see that anyway. A judge is going to want to know, did you knock on every door and exhaust every other possibility before you bothered me with this case, okay? Negotiation comes first, but remember, you have to appeal to the institution's self-interest. You have to make it clear to them that not censoring your publication isn't just the right thing for you, it's the right thing for them. It's in their own self-interest. What we encounter is the main reason that institutions censor is to preserve their PR image, right? It's a competitive recruiting environment out there. It's competitive for good students. It's competitive for donations. Institutions want to project the best possible public image. Is censorship really the best way to protect that image? I want you to think about what Obi-Wan Kenobi said to Darth Vader in the first original Star Wars movie, right? Right before Darth Vader gets him with the lightsaber, what does he tell him? He says, "You can't win, Darth. If you strike me down, you will make me more powerful than you can possibly imagine." And that's what censorship does. That's what censorship does. It takes that story and it makes it more powerful because people want to read what the government is telling them they can't. And we live in the 21st century where it's impossible to keep secrets, okay? So, Mr. President, that story that you want to censor, that story's gonna get out. That story's gonna get told. And now you're gonna be dealing with two bad stories instead of one, because you're gonna be dealing with a bad story about how you disrespected the First Amendment, and you're gonna call exponentially more attention to that original story you wanted to conceal, because many, many, many more people will read it now. If that first negotiation doesn't get you everything you want, then it may be time to go public. That includes contacting the Student Press Law Center, but it also includes contacting your local media. Try to get them involved in the story. Sometimes that can have a decisive impact. We actually dealt with a case where publicity was the decisive factor in turning censorship around. There was a high school principal in Michigan who had told some students they couldn't run a particular column because it was too negative and it was too controversial. We wrote about it on our website. The principal had his Google alerts set so that his name would come up every morning to see where he had been written about. He saw this story about the censorship and he didn't like what he saw. He didn't like seeing his name and censor in the same word. And he called the students in and he said, "Run what you want to run," because he was more sensitive to the bad publicity of the censorship than the bad publicity of the column. So that can be an appeal to the institution's self-interest, which can be a much more powerful appeal than an appeal to the First Amendment and the Bill of Rights. Okay. This is where you think about turning to your alumni network. If your publication or your broadcast has been around for a while, you ought to have some kind of an alumni support system, even if it's very simple, even if it's just a group on Facebook, group on LinkedIn, group on Google+, something where people can exchange information and feel like they still have some ownership in that media outlet. Why? Because those people are your best allies in a censorship fight. The people who will be listened to, the voices who will be listened to, more than a student's voice, are the voice of community leaders. If you've got alumni who are lawyers, if you've got alumni who are financial contributors to your school, those voices are powerful. Those voices will be heard. What you want is an ally in the community who can speak for you in front of a board of trustees or a board of regents and say, "Hey, I had a great educational experience working on that broadcast, working on that website, working on that magazine, and I don't want you messing it up." Finally, think about going all the way up the ladder, even over the heads of your board of regents or your board of trustees. If you're at a state institution, ultimately, their bread and butter comes from their state legislature. Think about whether there is an ally, a friendly person, a set of ears on the budget committee or on the higher ed committee who might listen to what the institution is doing, because that's a phone call that will get returned. That is a phone call that will get results. Anybody have any questions? Yes, go ahead.
Is there anything I can do in advance to reduce the risk of getting censored in the first place?
Well, one thing you can do is be an educated consumer when you're picking your school in the first place. Frankly, we spend a lot of time looking at whether the dorms have nice restaurants and satellite TV and good treadmills, but we probably spend less time looking at the free speech policies of the school. It should be part of kicking the tires when you're checking out that school. Do you have a policy that guarantees me that I'm not going to be written up on disciplinary charges just because I publish a bad editorial? And if you don't have that, why not? If you don't have that, why not? If schools hear that from enough prospective students, that may be enough to turn them around. That may be enough to make them consider, well, we bought the rock climbing wall to get the good recruits in. We bought the nice treadmill to get the good recruits in. Maybe we need a good free speech policy to get the good recruits in. You also need, as part of building those allies out in the larger world, you need to cover the activities of your Board of Trustees and your Board of Regents. You got to get reporters and cameras in there all the time, wall-to-wall coverage. Why? 2 reasons. First of all, because if the Board of Regents or the Board of Trustees knows that you're there, they know that you're probably the only media outlet that is providing the public with coverage of that institution, right? They think they're pretty important. They think their stuff is worth covering. They know that if you went away, that would be a big loss. That would be a valuable loss to the public. They know that. The other thing is you build contacts, you build relationships. You don't want, if you've got to pick up the phone and call a member of the Board of Regents and say, help, you don't want that to be the first time you ever met that person. You want to already have the knowledge and the relationship and the recognition before you need to ask for help. It's what they tell you on airplanes, right? Locate the emergency exit before you need it. Locate your allies before you need them. If you're at a private school, get copies of the good free speech policies that are already in places like Tulane and places like Notre Dame, and take them to your institution and ask them, why don't we have policies as good as this? It's our experience that having good and clear policies actually winds up reducing controversy and not creating it. There are places that may be afraid of adopting free speech policies. They're afraid they'll tie their hands. Our experience is the opposite. Our experience is that it minimizes controversy and conflict and dissent if you have clear rules in writing that say, here are the things you can censor, and here are the things you can't. That way we don't have to speculate when we're in Colorado based on some 15-year-old federal court case from Ohio. We know the rules because they're already in writing and everybody has agreed upon them. Remember that you can use your editorial page to advocate for better free press protection. You can use your opinion pages to advocate for the rights of the press. It has worked in other states. There are 8 states that extend greater protection to the student media than the bare minimum allowed by federal law. 7 that extend it to all student media, and an 8th, Illinois, that extends it only to the college-level student media. It is possible to get better protection from your legislature than the bare minimum that the law requires. Finally, please remember this. The best censorship insurance you can buy, the best way to win a censorship battle is to make sure that you use good judgment and observe professional standards of conduct, and that your journalism is bulletproof. That's the kind of journalism that survives and wins a censorship controversy. If your journalism is going to be blown up on a big screen in a courtroom in front of a jury of adults who look like your grandma, it has got to be journalism that is so solid that people in the adult community respect it as worthy of protection and want to see it protected. If your journalism is full of errors, if it's full of mistakes, if it's sloppy, if it's frivolous, a judge and a jury are going to look at it and say, this is the journalism you want me to protect? This is the journalism that you think Thomas Jefferson and James Madison were thinking about? So you want to pursue the substantive stories. There are people who will say, there are people who in the face of censorship will retreat and will be afraid. They will avoid doing the big story because they know it will be controversial. Don't do that. Don't censor yourself. Pursue the big story, because the big story, the substantive story, the breaking investigative story where you as the college media are bringing new information to the public that they wouldn't get anywhere else, that's the story that will best hold up in a censorship controversy. That's the story that we hope you'll do, and that's the story that we at the Student Press Law Center are proud to get out there and protect. Well, that wraps up our discussion of the First Amendment and censorship, and we just want to encourage you to use all the resources that are available on the Student Press Law Center website, www.splc.org, to understand and intelligently protect your legal rights.